I have to look at them in advance.
Mm-hmm.
Okay. All right.
And Judge,
go ahead.
so Judge, if you have Walker, the other matter, Mr. Joseph.
Should work now.
I can hear you, Justin. That was the weirdest sound effect I've ever heard.
Yeah, it was looping. Whenever that happens, everyone's just got to hit mute and then it'll stop. But now I just can't see the court. Or they can't. Oh, there you go. Now it's back live.
Daniel, can you hear us?
Yes.
Okay, great. We're just waiting for the court to get back online. Sorry about this.
They're gone again.
All right. All right. Ms. Calzone, can you hear me?
Yes, Judge.
Mr. Talone, can you hear me?
Yes, Judge.
All right. And Mr. Steffner, can you hear me?
Yes, Your Honor.
All right. Camilla, can you get us back on the record? All right. All right. We're back on the record. Ms. Calzone, I believe you were making your presentation.
Yes, thank you, Judge. I believe we left off just speaking about Bridgeway Rehabilitation Services, which Mr. Steffner is currently under the care of. Jeffrey Tholen, who's written this letter that we have been discussing, he's seen 3 to 4 days per week. And with regards to the state's concern that Mr. Steffner was already under their care at the time that this happened, well, their treatment process is going to change going forward in terms of how they're dealing with Mr. Steffner. Mr. Tholen made the representation to me that he will be referring Mr. Steffner to their psychiatry team for an evaluation to see if maybe a medicine change or addition is required in this case, which may very well be the case. With regards to his public safety assessment, it's a 3-3 with a PML-1 recommendation. His prior offenses are from 14 years ago, 11 years ago, and 10 years ago, respectively. Those are all disorderly persons offenses. He only has one failure to appear. And again, that's from 10 years ago. So his criminal history is relatively non-serious and is quite recent this time. He's a lifelong resident of New Jersey. He was employed for 8 straight years at Goodland Country Club as a maintenance worker there. That was until recently, until just a couple months ago, I believe. He is a graduate of Hackettstown High School. He does also have a higher education certification from Gemology Institute in Manhattan. Our office has been in contact. I personally have been in contact with his mother, Jaredis Steffner, who is supportive of her son, was going to appear in court if we were going to have physical court appearance. And I would also note, Your Honor, that Jeffrey Tholen, who wrote the letter, was also willing to appear in court. Last week when I ran it by him, I indicated we're doing the adjournment. We don't know what's going to happen going forward. Obviously, he cannot appear virtually with us today. So, Your Honor, I would submit that Mr. Steffner is not going to get the mental health treatment that he needs in jail. He's being charged essentially with using words, again, which are directly stemming from the mental health issues that he's had. He needs to get back to PACT, which he cites as his strongest support system. Mr. Steffner speaks extremely highly of his experiences with PACT and refers to them basically as if they were family. And he's eager to get back under their care, to see the psychiatrist, to assess, what happened and how he can proceed and how he can address any concerns with his mental health that have arisen. Your Honor, we're not in the business of incarcerating nonviolent offenders for their mental health issues, and that's really what we have here. And I would submit, again, particularly in light of the current circumstances with COVID-19, adding another person to the jail who is not an inherently violent individual, who is not charged with violent offenses here, who's charged with using words, poorly chosen words that are a result of a mental health issue. I think exactly where he needs to be is outside under the care of the PACT team. So we are asking, Your Honor, that you follow the PSA recommendation and release Mr. Steffner on PML 1. And perhaps if the court feels that a mental health evaluation is appropriate, Mr. Steffner is ready, willing, able, and planning to seek mental health treatment upon his release. He's constantly been involved in these mental health programs before. He relies on them heavily, and he acknowledges that he needs to go back and maybe get a reevaluation done either with PACT or at the order of the court. Thank you, Judge.
Okay. Anything else, Mr. Talone?
Judge, just briefly, my concern with him is that he was currently in this program and he committed these offenses while on that program, and he has no ability to have an update until he's actually released, allegedly, until he's allegedly released, and then they're going to evaluate him and see what he needs at that point. So that doesn't really give, at least the state, any real assurances as to what's really going to be happening when he's released as to the next step or in the interim until he's maybe stabilized on new medicine, et cetera. And Judge, in regards to defense counsel citing that this is an issue because of COVID-19 and we shouldn't be putting someone else in there, I don't see that as a valid argument, Judge. It's more existential, if anything. We should not be relying on the fact that there's a health crisis going on in order to not detain this defendant. I would cite to the case involving the looking at somebody's ailment, such as the case court did with the pregnant female when they asked her, when the judge considered that in order to release her, and the appellate court has struck that down, Judge. I would cite that as very similar in that nature. So with that, Judge, again, the state would ask that he be detained.
All right, thank you. Mr. Steffner, did you want to say anything?
Just that I had paid an additional $400-something to Gold's Gym that same day or the day before for credit, that I owed gym membership from before I became homeless, that I stopped going to the gym. So it was more than $82. It was my whole.
All right, we don't want to get into the underlying charges or anything like that. Okay.
just respond briefly to the state's
Sure.
comments. With regards to concern that he's not going to get mental health treatment until he's released, well, then we really have a chicken and an egg situation, because he's not going to get treatment until he's released, but the state is arguing that he should not be released until he gets treatment. So we're not accomplishing anything by keeping him incarcerated right now. Again, these are nonviolent offenses. And with regards to the argument as though this is an ailment of Mr. Steffner's, this is a systematic issue that we're dealing with, where we're having issues with everybody's safety. So I think it is a valued argument to say that we don't need another person sitting in jail and potentially being exposed when they could be at home, perhaps, with his mother, or, under the care of PACT. He could be at home safely like the rest of us, and he is a nonviolent offender. So thank you.
Well, actually, where is he going to be residing if he's released?
He would be residing at that same hotel that he was at, Your Honor.
Okay.
That hotel was arranged through PACT. When I reference his mother, it's just that he does have close contact with his mother. He does not live with his mother, just for clarification.
Right. All right. The general statutory purpose of New Jersey Statute 2A:16215 is to reasonably assure three things. One is that the defendant will appear in court when required. The second is the safety of particular people or the community generally. And the third is that the defendant will not obstruct the criminal justice process. Here, there is a rebuttable presumption against Mr. Steffner's detention. That is that there's a presumption that there are non-monetary conditions of release and or some amount of monetary bail that would satisfy those three statutory purposes. To rebut the presumption of release, the court must find, and the state must prove by clear and convincing evidence, that there is no amount of monetary bail and or non-monetary conditions of release that would reasonably assure the three statutory goals. Evidence is clear and convincing when it produces in the mind of the trier of fact a firm belief of conviction as to the truth of the allegation sought to be established, meaning that the evidence is so clear, direct, weighty, and convincing as to enable the court to come to a clear conviction without hesitancy of the truth of the precise facts and issue. I have considered the PSA in this case. Again, a PSA is not a binding, is not in any way binding on the court, is a tool for the court to use, and something that should be considered. I have considered it. The scores for Mr. Steffner are 3-3 for both the risk of failure to appear and the risk of new criminal activity. There is no new violent criminal activity flag. The overall recommendation is release on monthly reporting conditions. In addition to the PSA, the court should consider the nature and circumstances of the alleged offense and the weight of the evidence. Again, we have just these, there's a truck going by. I'm just going to wait for that to go by. All right, the Washington Township Police Department does give a great deal of detail as to the alleged conduct. Again, there were multiple workers, I guess, for the billing staff, for radiology associates who were threatened. Mr. Steffner was described as being irate, and this is all due to collection of a bill, a relatively modest bill of $86, and the threats were, coming over there with a can of gas and burning the building down, threatening to slit people's throats, etc. Just completely, again, describing it as disproportionate is an understatement. Ms. Calzone is correct that these are words. However, the problem is the effect on the listener of those words. The people who are hearing these threats don't know whether Mr. Steffner does or does not have the capability of carrying the threats out, and it puts them in grave fear. And that obviously is the purpose of the prohibition on making terroristic threats. On the other hand, I am confident that Mr. Steffner, did not intend to actually carry out these threats. It's just that the people hearing them didn't know that and were understandably quite alarmed at them. The weight of the evidence is quite strong. The Washington Township Police have documented all of the allegations with written statements from the call takers, and I guess provided copies of the copies of the telephone calls themselves. So the weight of the evidence is very, very strong. Looking at Mr. Steffner's history and characteristics, he does have a court history. They are disorderly persons offenses, 3 of them. They go back in time quite a long time. Simple assault, criminal mischief, and another simple assault. There was 1 failure to appear, but again, that goes all the way back to 2010. There are no indictables, it does appear that there is still an active final restraining order that was issued back in 2006. But again, the history here is not a serious criminal history. And again, the allegations are really of someone who is suffering from mental health issues. Again, Mr. Steffner was not on probation, parole, PTI, conditional discharge, or anything like that. Again, while I don't find that Mr. Steffner ever intended to carry out these threats, it is still a serious matter that people are being subjected to even having to think about whether someone intends to, burn their building down or slit their throats. I don't have particular concerns about failure to appear or obstruction here. When I weigh and balance all of those factors, I do conclude that there are conditions of release that will satisfy the 3 statutory goals, and that the state has not established by clear and convincing evidence that there are none, no conditions that would do so. So I am going to release Mr. Steffner subject to the following conditions. First and foremost, Mr. Steffner must continue with treatment at the Bridgeway Rehabilitation Services PACT, PACT4 program. I'm going to rely on Ms. Calzone's representation that program will conduct either a psychiatric or psychological evaluation of Mr. Steffner. That's a requirement. And Mr. Steffner is ordered to comply with whatever recommendations come out of that evaluation. In addition, Mr. Steffner must provide or sign a release authorizing pretrial to get the records from Bridgeway and any other physicians that are involved. I want them to have full access to the records. Can we condition his release on that, Tony? Is that how it's done? Yes, all right, so I'm going to condition his actual release from the jail on him signing that release. How exactly that's going to get to him, Ms. Calzone, I think you'll have to figure that out, okay?
Sure, I'll try.
Okay. He is required to reside at that Broadway hotel or motel, and report any address changes immediately to probation. He is on bench warrant status for any failure to appear at the Bridgeway program. So he must do that. And again, he must fully comply with all of that program's requirements. And just for the record, I don't find the COVID-19, I don't give any weight to that. We are in the midst of a pandemic. I don't find any reason to believe that Mr. Steffner or any other person would be at more risk, frankly, in the jail than they are outside the jail, given the pandemic status. The sheriff is charged with safeguarding the health of all prisoners. So I don't put any weight on that, but I do think, as I said, with the conditions that I just ordered, that Mr. Steffner, that the statutory goals will be met. The next appearance for Mr. Steffner, I want you to repeat this, Mr. Steffner, is before me on April 6th for a pre-indictment conference. All right, would you repeat that, Mr. Steffner?
April 6th for pre-indictment conference.
Right, before me, I'm on the 4th floor in the Morris County Courthouse.
Do you know what
all right,
time?
and
Do you know what
8:30.
time?
8:30 in the morning. All
Okay.
right? And again,
Yes, Your Honor.
obviously no more conduct, threatening people or anything like that. And do you understand that you must report to the Bridgeway program?
Yes, Your Honor. What about PTI in the morning? Do I have to do that?
I'm sorry, what is that?
Is there some kind of PTI? They said the last time I went to court that I had to see PTI, call PTI in the morning at least too, pretrial intervention.
Well, you have to comply with pretrial monitoring level 1, which is monthly reporting.
And that's the pact?
No, that's separately. You have to call in to your pretrial officer on a monthly basis.
When is the next time? When is the first time I have to do that?
Tomorrow?
Level 1's, Your Honor, that have to report by phone to the office
When does he have to do that first?
tomorrow morning.
Tomorrow morning.
Okay,
Okay.
I'm just hoping problem doing that because I'm just hoping I can get home because nobody
All right,
answers
well,
my.
Daniel, make sure you don't have a problem doing that, okay?
Okay.
All right, but
Okay.
the other thing is you're not going to get out of jail until you sign a release authorizing pretrial services to get your records from Bridgeway and any treating physicians. Do you understand that?
Yes, Your Honor.
Okay.
But
That'll be
one last
brought
thing.
over. That'll be brought over to the jail.
okay.
Okay. Anything else from counsel?
Judge, just one last thing. I don't know if you mentioned this, but no contact with the radiology group or any of the people that work there?
Yeah, actually, I did not mention that. So, Mr. Steffner, in addition, another condition of your release is that you may have absolutely no contact with radiology associates or anyone trying to collect a bill on their behalf.
Okay, thanks.
All right. Okay, anything else, counsel?
No, Your Honor.
No, Judge. Thank you.
Thank you.
Okay, thank you. All right. All right, did you get any exhibits for Mr. Joseph? Nasir Joseph? Nothing?
He said withdrawal, Judge.
Oh, it's a withdrawal?
Yeah. And then the other one is a actual.
Yeah, okay. All right, is there, I was just informed by Tony Montanez that there's a withdrawal as to Mr. Joseph, is that correct?
Yes, Your Honor. Bradford Seabury for the state. I spoke with counsel on that matter yesterday, And based on our discussions, we see it appropriate with a agreement to have Mr. Joseph report monthly to pretrial services.
Okay, can we bring in Nasir Joseph? We'll get that on the record.
He's right down the hall. Give me like 2 minutes. I'll put him on the phone with you.
Absolutely, thank you.
Tony, did you say that that release would be brought down to the jail for Mr. Stefner?
I'm sorry, can you repeat that, please?
Sorry, did you mention that the release would be brought down to the jail for Mr. Stefner, or is that, how would we arrange that?
So if you have, he's in a treatment program now, right?
Yes.
Yes, he has no problem signing it, just physically, like logistically. At him.
Right, so the program will have to send a release to the jail for him to sign, because we don't have those releases here. So it has to come from the program, and then the jail can send it to us after that.
Okay, so.
All right, so I think, Ms. Calzone, you're going to have to contact Mr. Tholen
Right,
and then
Okay.
ask him to get you the forms or get them to the jail and get, so that Mr. Stefner can sign them.
okay, thank you for clarifying.
Okay, that, I didn't know that either, but thank you for, Tony. All right.
Yeah, hey,
All right, Mr. Joseph?
yes,
All right, this is State of New Jersey against Nasir Joseph. The promise gavel number is 2346, and the complaint warrant number is 2020-48-1421. Earlier this morning, we conducted Mr. Joseph's first appearance, and we were scheduled for a detention hearing. Let's begin with the appearances of counsel.
Good afternoon, Your Honor. Bradford Seabury for the state.
Good afternoon, Your Honor. Brittany Calzone on behalf of Mr. Joseph, appearing via the report.
All right, Mr. Joseph, before you were present, counsel advised me that they have come to an agreement. The state will be withdrawing its motion to detain you. And Mr. Seabury, would you put the terms of the agreement on the record?
Judge, what I had discussed with counsel would be monthly reporting to pretrial services.
Okay. All right. So is that right, Ms. Calzone?
That's correct, Judge.
Okay. All right. So again, the state's motion to detain is dismissed as withdrawn, and Mr. Joseph will be released on PML level 1 with monthly reporting. Mr. Joseph, that means that you have to call in to pretrial tomorrow when you're released, and then monthly thereafter. Do you understand that?
yes,
All right, and your next court date is on April 13th before, not me, another judge, Judge Ironson, okay, at 8:30 on April 13th. So would you repeat that so I know that you know?
yes, April 13th, 2020.
Right. Okay, it's Judge Ironson.
8:30, right?
Correct.
Yes.
Okay, all right.
Yes.
Anything else, counsel?
No, Your Honor.
No, Your Honor.
Okay, thank you, Mr. Joseph.
All right, you're welcome.
All right, good. I'll see you in the other room. I'll be back.
Okay, all right, so that one, just sign, right? All right.
Just give me 1 second. Can you leave my phone?
Yeah. All right, Mr. Walker, can you hear me?
Yeah.
All right. All right, this is State of New Jersey against Elijah Walker. The promise gavel number is 20393-001. The complaint warrant number is 2020-56-1421. That's the municipality code for Montville Township. Earlier this morning, we conducted Mr. Walker's first appearance, and we're now about to conduct the detention hearing, and we'll begin with the appearances of counsel.
Good afternoon, Your Honor. Bradford Seabury for the state.
Afternoon, Your Honor. Brittany Calderon on behalf of Mr. Walker, appearing via video.
All right. Again, it's March 18th, 2020. The first appearances and detention hearings today are being conducted via a video. Both counsel are appearing via video. No one is in the courtroom, and all of the defendants are appearing via video link from the Morris County Jail. All right, Mr. Seabury, the state has moved to detain, correct?
Yes, Your Honor.
And have you provided the limited discovery required for a detention hearing to Ms. Calzone?
Discovery was provided, Your Honor, as well as the exhibits the state intends to rely on today.
Ms. Calzone?
Yes.
You received that? Okay. All right. Mr. Walker, if the court makes a finding of probable cause as to the charged conduct, you will enjoy a rebuttable presumption against being detained pre-trial, and the state must prove by clear and convincing evidence that there is no amount of bail and/or non-monetary conditions of release that will reasonably assure three things. The first is that you will appear in court when required. The second is the protection of the safety of any person or the community generally. And the third is that you will not obstruct the criminal justice process. Do you understand that's the purpose of a detention hearing? Mr. Walker?
Yeah.
Do you understand that's what detention hearings are all about?
Yeah. Yes, sir.
Okay. All right. You do have the right to testify and to challenge all of the information that the state presents. Your attorney is also allowed to tell me your version of the facts. That's called an attorney proffer. Do you understand that?
Yeah.
The general rule is that if you do decide to testify, your testimony is not admissible against you in court. However, there are 5 significant exceptions to that general rule where your testimony can be used against you. The first exception to the general rule is that your testimony is admissible in any proceedings relating to a subsequent failure to appear in court. Secondly, in proceedings relating to any subsequent offenses committed while on release pending disposition of these charges. The third is your testimony would be admissible in any proceedings relating to a subsequent violation of any conditions of release. 4, the testimony would be admissible in any subsequent perjury proceedings. And 5, also your statements would be admissible to impeach you should you testify in this case contrary to what you would testify to today. All right, do you understand that?
Yes, sir.
And for the time being, we'll proceed with Ms. Calzone's attorney proffer, and then at the end, I'll ask you if you want to testify, okay?
Okay.
All right. If you are detained pretrial, the state must obtain an indictment from the grand jury within 90 days from the day you were first lodged in the jail, and bring the matter to trial no later than 180 days from the grand jury returning the indictment, although that 180-day period can be extended for various reasons. All right, do you understand that?
Yes, sir.
All right, any questions?
No, sir.
All right, as to probable cause, Ms. Calzone, I assume that you're leaving the state to its proofs?
Yes, Judge, thank you.
Okay, Mr. Seabury, I'll hear from you first.
Okay, thank you, Judge. Judge, for purposes of the record, I did mark 4 documents for your consideration. The first document would be S1, which is the complaint warrant 2020-56-1421. S2 would be the affidavit of probable cause. It's a 4-page detailed affidavit that was prepared by the investigating officer. S3 is the ESA. And finally, S4 is the report detailing the defendant's arrest at the time he was able to be taken into custody. So, Judge, those are the 4 documents that I'm offering for your consideration. And specifically, I'll point Your Honor to S2 as well as S4 for the purposes of this aspect of the proceeding and the determination of probable cause. Judge, I'd indicate that in this instance, there is sufficient probable cause for the 3 charges, which is third-degree receiving stolen property, 4th-degree obstruction, and 4th-degree resisting arrest. Judge, I think the 4-page detailed affidavit, which is much more detailed than you typically see with the ECDR system, and that was purposely done for Your Honor. It was prior probable cause determination was made by the municipal court judge. I think that in this instance, probable cause is made. Judge, I can detail the facts, at least I can outline the facts for Your Honor if that would assist in the purposes of the record, but I believe the probable cause statement speaks for itself.
Yeah, I have reviewed both S2, I guess, which is the affidavit in support of an arrest warrant by Detective Scott McGowan of the Montville Township Police Department. And in addition, S4, which is the Morris County Prosecutor's Office report. But for the record, why don't you just outline the facts as set forth in those documents? Can you hear me?
Judge, I lost a little bit of the connection, so I couldn't hear you. It was
okay. I
hear you good now.
Okay. I'll repeat it. I have reviewed both S2 and S4, S2 being the affidavit in support of an arrest warrant. It's a detailed 4-page document, affidavit by Detective Scott McGowan of the Montville Township Police Department, dated March 12th, as well as the Morris County Prosecutor's Office supplemental report. It's labeled, the reporting detective is Robert Kotzner, and that's dated March 13th. So I am familiar with those, but why don't you just outline that in general for the record?
Okay, for the record, Judge. So on March 5th of this year, the Montville Township Police Department received a report of a suspicious vehicle in the neighborhood in the early morning hours, around 3 in the morning. I think it was 3 to 4 in the morning. Police responded to that area. They were able to make contact with a motor vehicle. They attempted to make a motor vehicle stop. That motor vehicle fled. The officer gave chase in his vehicle. Ultimately, that motor vehicle that was being chased stopped. At that location, 3 individuals jumped out of the vehicle and fled on foot into the neighborhood or into the woods. I'm not exactly familiar with that location. The officer was unable to take those 3 individuals into custody. Other officers responded. They attempted to set up a perimeter that evening or that early morning. The 3 individuals were not located. Thereafter, an investigation was started by detectives from the Montville Township Police Department, as well as detectives from the County Auto Theft Task Force. Upon that investigation, there was suspects identified, including Walker. Initially, that was done through video evidence. A 7-Eleven in the area of where the suspicious call was canvassed. On that video, Mr. Walker was identified and he was connected to the vehicle. In addition to that, the investigation located Mr. Walker's fingerprint in the vehicle on a telephone device. The victim confirmed that he does not know, or he or she does not know Mr. Walker, and that Mr. Walker was not supposed to be in his vehicle. Officers from the Montville Township Police Department, as well as the county, went out to a location after that they believed Mr. Walker was at, and they did make contact with Mr. Walker. However, again, Mr. Walker fled on foot and attempted to evade capture. Police were ultimately able to locate Mr. Walker and take him into custody, and that's why he's before Your Honor today. In this instance, there's both fingerprint evidence tying Mr. Walker. There's the MVR video tying Mr. Walker to this crime, as well as the 7-Eleven video that ties Mr. Walker. In addition, there was an admission made by Mr. Walker that he was, I just don't want to.
Yeah, it says on March 12, 2020, Elijah Walker was interviewed at the Montville Township Police Department and admitted that he was inside the vehicle when it was stopped and that he took off running.
Yes, it was a very short state. It was a very short statement, and I didn't want to make it into anything in addition than what it was. So I would indicate that as well. So, Judge, in this instance, I think there's well beyond probable cause for the charges that were reviewed by the municipal court and found to be probable cause: the third-degree receiving stolen property, fourth-degree obstruction, and fourth-degree resisting arrest. And just to be clear, those particular charges are only pertaining to the conduct in Montville. The conduct that occurred at the time of his actual custody, taken into custody in Passaic, unfortunately, the ECDR system has not let us charge it yet. So it's not that obstruction or that resisting that's included, but it will be ultimately indicted.
Okay, Ms. Calzone?
We submit, Your Honor, with regards to probable.
Okay. All right, probable cause has been described by the New Jersey Supreme Court as a well-grounded suspicion that an offense has been committed. That's State versus Sullivan, 169 NJ 204, 2001 decision. The Supreme Court has described probable cause as a low burden, and that probable cause is a flexible, non-technical concept and should be determined using common sense, practical considerations, and not technical considerations. Here, the very detailed affidavit of Detective Scott McGowan of the Montville Township Police Department more than adequately establishes probable cause for the charges. That's receiving stolen property, obstruction, and resisting arrest, eluding. Again, I guess it was a Toyota RAV4 that was the stolen vehicle, is linked to Mr. Walker by fingerprint evidence, by some of the video evidence that's described in the affidavit, and of course by the admission that was made, as that I just read from the report, allegedly made, I should say, from the report or from the affidavit that was submitted in support of the arrest warrant request. So there is more than adequate showing of probable cause. All right, we'll move on then to the detention hearing, and I'll hear first from the state and then from Ms. Calzone. Mr. Seabury?
Okay, thank you, Judge. And, you know, this is one of those cases where I almost don't want to oversimplify this, but perhaps I will. When I'm focusing in on both the nature and circumstances of the offense charged and the weight of the evidence, and just looking at the facts for this particular case, the facts in and of themselves suggest the need to detain this defendant. So on two occasions, both on March 5th and then ultimately on March 9th, when the police were able to catch the defendant shows what his intention is here, which is not to show up to court, not to be compliant with what the government is looking to do in this instance, Judge, which is to move this case ultimately to a trial. And Judge, you know, you have the defendant both fleeing in a car and then ultimately on foot, and then you have the defendant fleeing again on the 9th. I think that in and of itself and again, I said, Judge, I don't want to oversimplify this, suggests that the only way that we're going to ensure that this defendant shows up at future hearings and ultimately for his trial is if he maintains residence in the Morris County Correctional Facility. So, Judge, I think that in and of itself would suggest that the state has, by clear and convincing evidence, met its burden and shifted that presumption of release. However, Judge, we have more because in this instance, we not only have the defendant's conduct and the strong case that the state has, but we have the fact that while the defendant is only 18 years old, has been arrested at least 3 times and has a pending, at least 2 pending cases. One of them may have been downgraded, but has an indictable pending case for possession of a weapon for unlawful purpose. And that is why the tool is provided a 2-4 with no flag and no release recommended. Because, Judge, at 18 years old, we have an individual who's really short time as an adult had a lot of involvement in the criminal justice system, and it's picked up those 3 arrests in short order. That, in conjunction with him fleeing from police, I think gives us no other choice. I would suggest to Your Honor, most respectfully, that this defendant be detained and that he stay detained until his trial. All right.
Now, that Passaic charge, I believe it says on the PSA that it was possession of an imitation firearm. Is that correct?
Yeah. Judge, it says subsection E, so I did review that, and it's an imitation firearm with an unlawful purpose. I don't have any other details of that particular case other than what's on the rap sheet or that it's accurate on the PSA.
Yeah, again, subsection E, and it's 2C:39-4, says any person who has in his possession an imitation firearm under circumstances that would lead an observer to reasonably believe that it is possessed for an unlawful purpose is guilty of the crime of the 4th degree. All right, and the other question that I had for you, Mr. Seabury, is, as you know, PSAs do not capture juvenile records, and as you pointed out, Mr. Walker is just 18 now. His I'm not actually sure exactly when he turned 18, but is there a juvenile history? Because I don't have the full CCH.
So Judge, on page, looking at the full PSA, and there is an indication of a prior juvenile history. It looks like 3 different cases. One from
Everything
2012.
was supposed to be expunged
Okay.
when I turned 18.
Hold on, please don't talk.
Oh, okay. I'm sorry. You're right. Let me just look at that.
So it's a 2012, 2016, and 2013, it looks like.
Yeah, I don't see any adjudications of delinquency, actually. It says deferred disposition. I think for all
Yeah, I
of
see
them.
things like bench warrants also listed. So
Right.
if we're going to
Okay.
drill down into the juvenile history, I would suggest that that's concerning, but it's certainly indicative of what this defendant does. He runs from the police and doesn't show up when he's supposed to show up.
Okay. All right. Ms. Calzone?
Thank you, Judge. First, addressing the weight of the evidence here. This alleged vehicle, which these 3 individuals fled from, it should be noted that there's no allegation that Mr. Walker was the driver. There was 2 other individuals involved. One is still unapprehended upon information and belief and based on the discovery I've been provided with. The only physical evidence tying Mr. Walker to the car at all was 1 fingerprint found on a phone in the car. It was not found on the car itself, which is in contrast to his co-defendant, who's a juvenile, so I won't name them, but that co-defendant who is apprehended, his fingerprints were found actually on the vehicle itself. There was also 3 phones. These prints were found on 1 out of 3 phones in this vehicle. He's not charged, none of them are charged with stealing this car, and I think the state is going to have an issue proving knowledge that the car was stolen, particularly since Mr. Walker was not the driver. And there was a statement made by the co-defendant who apparently has every reason to point blame elsewhere. That co-defendant has a record, even though he's a juvenile. He's already built up a record. He's known to the police, and he's also already on probation, unlike our client. And with regards to the statement that was made allegedly made by Mr. Walker, Detective Scott McGowan, in the affidavit in support of the arrest warrant, which Your Honor is in possession of, it states that Elijah Walker was interviewed at the Montville Township Police Department and admitted he was inside the vehicle when it was stopped and that he took off running. However, when we look at the police reports provided by Detective McGowan, also in the discovery, that statement is reflected as such. Detective McAuliffe and I interviewed Elijah after going over his rights at approximately 15:08 hours. Elijah did not furnish much information, and only after about 12 minutes, he exercised his right to remain silent and the interview was ended. He was then brought downstairs and processed. While he was downstairs, he told one of the detectives he wished to speak with me again. I brought him back up to the interview room and read his Miranda rights again. The only additional information he provided was confirmation that he was inside 7-Eleven in Montville with quote unquote slump boy and J Dot, but would not give up any names. So I'm unsure of why Detective McGowan's affidavit, his sworn affidavit, states that Mr. Walker had put himself in that car and had put himself fleeing from that car in the statements he allegedly made. That's not what's reflected in Detective McGowan's own police reports. So I have not been provided with that actual statement, which I presume was recorded. We have not been provided with that yet, but there is an obvious discrepancy here, particularly in that one statement. One version of his statement places him at the scene and one version does not. Those are two very different statements, Your Honor. With regards to the PSA, he is a 2-4. But for the repeated arrest triggered recommendation, the PML recommendation would be for release on level 2. He is not currently, understanding he has the 2 pending charges, he's not currently on any level of supervision as reflected on his PSA. He was ROR'd or given, he was given summonses in the latter 3, and then for the one from Passaic, I presume he was either given a summons or ROR'd. So I submit that PML 3, which would require him to report weekly, would significantly enhance the reporting requirements that he's currently on, and ensure the 3 goals of the CJRA. With regards to the current charges he's facing are 3rd and 4th degree. They're nonviolent. The pending charges he's facing are 4th degree and disorderly persons offenses, also nonviolent. He has absolutely no prior convictions, and therefore he is PTI eligible at this point. I don't know how these cases will be disposed of, but at this point he still has no convictions, and these are all 3rd and 4th degrees, so he is eligible for PTI on these. As Your Honor noted, there are juvenile contacts with the law. However, I would note these are from 4, 7, and 8 years ago, respectively. They were deferred disposition, not adjudicated delinquent, and then they were also disorderly persons and PDP offenses. So again, very minor infractions of the law. I would say again, Your Honor, he's only 18 years old. His mother has been in contact with our office on numerous occasions over the past few days. She's extremely concerned about his well-being. Again, in light of the current situations with COVID, that has increased her concerns. If he were released, she has told us that he is going to be welcomed into her home where he was living beforehand and would be under her supervision. He is a high school graduate, and he is looking into going to college for criminal justice, in fact. And he has just completed orientation for Job Corps, where he's going to receive vocational training. This is information received from his mother because, unfortunately, again, I have not had the opportunity to speak with Mr. Walker myself. However, I'm just proffering this information that his mother has given us. I'm not sure when he was supposed to start Job Corps. Mr. Walker also suffers from benign bone tumors, which apparently result in calcified growths on his bones. I'm no medical professional, but I have been informed that this is a painful condition and that it requires medical monitoring. And I don't think he's going to receive this treatment while he's incarcerated. So, Your Honor, I would submit that he's not a violent offender. There are issues with the proofs in this case, particularly with regards to whatever statements they're saying he may have made. The police reports themselves are inconsistent. There's nothing tying him to that vehicle absent the one fingerprint on a phone, which is a tangible, movable device, which could have been taken in and out of that car by anyone. Would allow, he is just 18, would allow him to be released into his mother's custody and report as required. Thank you, Judge.
Okay,
If I may say something,
yeah, go ahead.
the day that I was arrested, when the police officer,
Hold on. The only thing, Elijah, is that I don't want you to discuss any conversations you had with the police at this time. We haven't received your statement. So we're just going off of what we have here. So I'm not saying anything. These are just the versions of events we've been provided with. So I'm going to ask that you don't make any statements factually here, okay?
no, I was gonna describe how the police officer. Well, I'll just talk to you if I can in private.
I know, and I apologize because
All right.
normally I would lean over, but I can't have
Well,
you tell me.
My understanding is that they will provide a private phone if you want to speak with him privately.
Yeah.
You can do
Elijah,
that.
Do you think that is what you're going to tell me going to change what I'm saying?
Not really.
Not really. Okay, so my advice then would be to tell your attorney who's assigned to my office. Okay,
All right.
let them know whatever happened with the statement.
All right.
Thank you.
All right. Just give me a minute I want to review the exhibits a little more. Okay, all right, is there anything else anyone wants to say before I make my findings?
No, Your Honor.
Ms. Seabury, anything?
No, Judge, sorry, it took me a minute to unmute there.
Okay, all right, thank you. All right, the general statutory purpose of New Jersey statutes 2A:16215 is to reasonably assure three things. The first is that the defendant will appear in court when required to do so. Second is the safety of persons in the community, either particular people or the community generally. And the third is that the defendant will not obstruct the criminal justice process. In this case, there is a rebuttable presumption against detention. In other words, that there exists some amount of bail and/or non-monetary conditions of release that will satisfy the three statutory purposes. To rebut the presumption of release, the state must prove and the court must find by clear and convincing evidence that there is no amount of monetary bail, non-monetary conditions of release, or some combination that would reasonably assure the three goals. Evidence is clear and convincing when it produces in the mind of the trier of fact a firm belief of conviction as to the truth of the allegation sought to be established, meaning the evidence is so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue. The court can and should consider the public safety assessment and the recommendation in the public safety assessment. I have done so. The scores for Mr. Walker are a 2 of 6 on the risk of failure to appear and a 4 of 6 for the risk of new criminal activity. There is no new violent criminal activity flag here, and none of the charges are of a violent nature. However, the overall recommendation from the PSA is no release recommended due to repeated arrests while on pretrial release. Those pending charges are set forth in the PSA, and there's a 4th degree possession of a weapon for an unlawful purpose and imitation firearm, as we went over earlier, in Passaic County, and 3 disorderly persons offenses that were charged by way of a complaint summons. And there, let's see, it looks like 2 criminal trespasses and a theft by unlawful taking. Again, all at the DP level. And as we've gone over, Mr. Walker, who just turned 18, has no indictable convictions and no other adult convictions. Again, he just turned 18. He does have the juvenile matters that we discussed, one of which goes back to 2013. The next was May of 2016. And actually there was one December of 2012 as well. All of them appear to have resulted in deferred dispositions. So again, I have considered the recommendation in the PSA, but it is in no way binding on the court. I have detained individuals with release recommendations, and conversely, I have released defendants who had no release recommended. The other factors that the court should consider include the nature and circumstances of the alleged offense and the weight of the evidence. The nature and circumstances of the alleged offense really are a sort of deliberate theft scheme with two other individuals, or at least two other individuals, driving around, in this case, Montville, looking for cars to break into and steal whatever is available in them. The car itself that was being used is a stolen vehicle, stolen out of Wallington, New Jersey. And again, with the perpetrators dressed in all black, wearing, finding there were black gloves found. There was also a, looked like a marijuana grinder in the car. Another car key that didn't belong to the owner of the stolen Toyota RAV4. So in terms of, as I say, the nature and circumstance of the alleged offense, it's a the allegations are of a deliberate theft, ring, and scheme. And again, it's described in a fair amount of detail. The weight of the evidence, again, Ms. Calzone has correctly pointed out that the initial attempt to stop the vehicle resulted in the all three occupants bailing out, as the affidavit in support of the arrest warrant said, and none of the folks were caught at that time. However, based on the subsequent investigation, including the fingerprints that were found on various phones in the car, one of them, one of the fingerprints on one of the phones came back to Mr. Walker. And there was also video surveillance from the 7-Eleven with the three males that are described, again, in a great deal of detail. It's difficult for me, since I'm not seeing the video, to see how clear or unclear any identification would be of Mr. Walker or the others. So the weight of the evidence I would describe as about average, as opposed to being strong. There will definitely be some issues for the prosecution. It is bolstered, however, by the statement, again, allegedly made by Mr. Walker, admitting that he was inside the vehicle and that he took off running. Again, whether there are Miranda issues or voluntariness issues with regard to that statement remain to be seen. And that would be the appropriate subject of motion practice if the case goes that far. Again, I guess I've covered another of the factors, which is the history and characteristics of Mr. Walker. Again, very young. He does have some things going for him. He's a high school grad, was seeking some vocational training. I guess if the allegations are true, it's really of someone who is making some very, very bad mistakes about the people that he's hanging out with and the conduct. This is kind of the fork in the road for Mr. Walker and others. Again, I don't want to prejudge the facts here, but again, if the allegations are true, it's of a very young man heading down the wrong path and not the right path. Again, I guess most concerning to me is the fact that Mr. Walker is he's got the pending charges out of Passaic County. Again, difficult. Mr. Seabury wasn't able to get any of the details, I guess, on the Passaic charges. It is a fourth-degree crime and 3 disorderly persons offenses, so not the most serious in the world, but it is concerning. On the other hand, as Ms. Calzone pointed out, he was released on his own recognizance, apparently, on those charges. Obviously, there is a danger to the community in the sense that this is an organized, or the allegations are of an organized theft ring, so that does present dangers. And I really don't have concerns. I realize it is true, certainly, that Mr. Walker is accused of fleeing twice, actually. The original stop, which the flight was successful, at least from preventing an immediate arrest, and then, again, the second time, which is described in the Morris County Prosecutor's Office report. And that was when the arrest was attempted to be made. The description says, I observed him look with a shocked expression at my police badge, which was on a chain directly in the center of my chest. He immediately, meaning Mr. Walker, he immediately turned around and took off running on foot. I ran after Elijah Walker, who fled behind an apartment building. Goes on to describe the chase, and all right, and eventually the Passaic police advised that they had located and apprehended Mr. Walker. So those are not, the flight is not a helpful factor for Mr. Walker. All right. All right. After weighing all of these various factors, and I'll describe this a little more, while this is a very close case, I am not clearly convinced that there are no conditions of release that would reasonably assure the 3 statutory purposes. I do respect and give weight to the recommendation in the PSA. However, I'm not going to give it a great deal of weight because the most serious pending charge is the 4th-degree charge. The other charges are DPs. Mr. Walker is PTI eligible since he has no prior indictable convictions. At least now, obviously the 4th-degree indictable in Passaic has not been resolved and is still pending. He was released apparently on his own recognizance out of Passaic, so a higher level of pretrial monitoring has not yet been attempted with him. He does not have failures to appear or again, he does. It is of concern that he did flee twice, which strikes me as just, at least in part, due to immaturity rather than anything else. He's gonna eventually get caught. Just like if he doesn't appear in court, he'll eventually be picked up on a bench warrant. But I do find that there are conditions that will reasonably assure both his appearance in court and the safety of the community. I'm going to place him on PML level 3, which is going to require in-person reporting every other week and by phone reporting every other week. So, Mr. Walker, you'll appear in person here, right? Or
Yes, Your Honor. Is he from Morris County?
no? I'm also going to require him, and we need an address, Ms. Calzone. He's going to be required to live with his mother.
Certainly, Judge.
Do we have that address?
Mr. Walker, can you confirm that this is the actually, I think your mother did confirm this address, but let's just check again. 614 North
North
9th Street,
Yes,
second floor apartment
yes. I'm on the lease.
in Newark, New Jersey. It's the address on the complaint, Your Honor. However, the complaint doesn't have the apartment number, which his mother did provide us.
Right. I'm sorry, did you say second floor or?
Second floor, that's what she said to us.
Okay. All right. Yes, that is the address on the complaint warrant. Mr. Walker, you're required to live there. Do you understand that?
Yes,
Yes. For the Madam Clerk, it's 614 North 9th Street, second floor in Newark, and the zip code is 07107. Again, PML level 3. Barred from possessing any weapons of any kind. Mr. Seabury, are there any other conditions that you seek?
Judge, I think a curfew should be imposed because the defendant clearly, the facts seem to support that he goes out in the evening hours, and that's when he commits his crime, where he comes into the county and steals cars and steals possessions out of cars. So in my view, he should not leave his house after 5 p.m.
All right, let me hear from you, Mr. Walker. Is there any reason you would have to leave your home after 5 p.m.?
not that I know.
You're not working, right?
No, I'm on disability.
Okay, all right. Okay, so Ms. Calzone, do you want to be heard on that? I think that's a fair request.
Yeah, I mean, I think 5 p.m. is pretty early. I mean, I would ask that Your Honor consider maybe 8 o'clock. I mean, that's still well within, that's before nighttime has set in, but at least that would allow him to get dinner, get home. I mean, I don't know his daily schedule, but I think 5 p.m. is very early.
All right, I'll tell you what, I'm gonna make it 7:30 p.m. That's about time of sunset this time of year. So from 7:30 p.m. to we'll say 6 a.m. in the morning, there's a curfew. You must be in your mother's house. Do you understand that, Mr. Walker?
Yes, sir.
Okay, again, I don't want you to respond to this, Mr. Walker, but you're going to be making some choices about which path you're going to go down in your life, and you got to make sure you decide carefully, and that includes the people that you hang out with, okay?
Yes.
Okay, anything else?
No, Judge.
All right, thank you, everyone.
Thank you, Judge.
Let me ask you, Tony, on the decision-making framework, does the seriousness of the pending charges factor in, or is it just that there are pending charges?
The seriousness.
It does, because that's it. I mean, he's got a fourth and 3 DPs, so they're not the most serious in the world, but it still came up with the no release.
It's a pending charge. You have 2 or more.
2 or more, okay.